If you're in the patent business, you will know the name Spherix. It's the company that bought 100 Nortel payments from Rockstar Consortium and several hundred Harris Corporation patents. But the company, founded in 1967 as a scientific research organization, has even bigger plans.
I think our market is changing dramatically and more rapidly than I think a lot of people appreciate. I think that more deals are being done in the public market space because most deals are really about risk allocation, right? If I'm a buyer and I'm buying for cash or wherever I'm buying for, you're looking to how am I protecting my risk? Sellers are looking for the same thing. The public markets give buyers and sellers another medium to deal with downside risk and upside potential. I think you're starting to see more deals being done for a combination of cash, stock, and back end. If you're in the private sector and you're dealing with a private company, there's really only two things you can move. You can move the amount of cash up front, or you move a back end interest, right? Moving into the public sector, you've got cash, you've got stock, you could issue bonds, there's other ways to allocate risk and other ways to put a deal together. So I think that helps, especially at a time where patent prices are cooling off the kind of high of 2010, 2011, things are pretty hot. I definitely think prices are coming down. So as prices are coming down, people are looking for ways to put a more holistic solution together. So I think we're starting to see some more deals in the public space, and we were really pleased to be part of that.
And as we see more deals, do you expect to see values start to rise again?
I think it's going to require some successful monetization efforts to see prices bottom and start to come out. I don't know if we've kind of hit a bottom yet or not. I think it will be incumbent upon everybody in the monetization space to do well, to kind of encourage more investment in the space. As you encourage more investment in the space, you're encouraging demand. As you're encouraging demand, prices should start to rise and come back up. In my opinion, one leads the other, and right now, between what's been going on in Washington and a few other factors, I think it's been a real cooling period. So until some of that, I think until maybe Washington permanently decides what it's going to do, or at least for the short term, you have a definitive answer and some positive monetization efforts, then I think you hit the bottom, and then I think you could start to come back up and see prices go back up.
So you would expect, and the market expects, that some of the questions around reform in Washington will come back. It's not going away.
I think so. You are seeing the Supreme Court right now issue some opinions that are answering some of the questions or issues being posed in Congress. I hear on a fairly regular basis from investors or potential investors about what's going on in Washington. Certainly when Senator Leahy pulled the patent reform from the Senate Judiciary Committee earlier this month, I think that was helpful and a step in the right direction. It was a slowing of really, really rapid reform that I'm not convinced was wholly thought out. Now that it seems they're going to be taking some time to think about it a little bit more, I think that's a very positive sign. I think there is a chance it resurfaces in the fall. If it does, it's going to have a dampening effect on the market. If it doesn't, I think it gets rid of some of the headwind that the market's currently dealing with.
You spoke initially about some of the benefits of being public. What are some of the challenges that poses?
Well, for the access to the public markets, the access to capital is great. It's a wonderful thing. The problem is that you're now layering on top of a monetization business all all the things you have to do to be a public company that can be very time consuming and they can be very expensive. You've got, in addition to having all the regular litigation counsel, you need a general counsel that deals with all your SEC related issues, just your natural filings. We're NASDAQ, so we've got fairly stringent audit requirements. So in addition to our accountants, we have auditors. They're expensive, so it adds a lot of, I think, cost to the traditional monetization strategy, which has always kind of been smaller LLC companies. So mostly cost. It also makes you have to be much more careful about what you say, when you say it. The disclosure of material non-public information is obviously a big no-no, and something you have to be very careful about. So in the private space, your investors can call you, talk to them all you want. In the public space, it is much more difficult for me to speak to investors. Because what you say to one, you have to say to all. So there's not the interaction always that I would necessarily like. And I think that's a challenge because investors have the right to know.
And you just joined the Russell Microcap Index, so do those challenges now grow as you become part of that group?
Well, not really so much. I mean, the benefit I think of the Russell is that it makes it easier for certain type of institutional investors to take positions in our company, which is very, very helpful. But we are already we're fairly widely held for a company of our size. That probably joining the Russell or not joining the Russell doesn't really impact that. It actually might make it a little bit easier because there may be some aggregation of our shares by more of funds or institutions, so it might help actually.
We've seen with the debate in Washington that there's a lot of negative connotations. The image of patents isn't great at the moment in some areas. Do you feel that you as a public IP company executive and the PIPCO community as a whole have a responsibility to improve that image, get the message across in terms of what IP and patent assets actually bring in terms of benefits to the economy?
We should. We probably are not focusing on it the way we should, but I do think that Spherix is a good example because I think the whole Nortel bankruptcy is a really good example. Patents had nothing, in my opinion, had very limited to do with the fact that Nortel went bankrupt. Right? It just went bankrupt, and all that was left to pay back creditors, as it turns out, were the patents. So the money that was generated and raised went to pay creditors. If you take that away, so if you strip out patents and go, well, we're not going to give these any, we're not going to let, if you didn't invent it and you don't make a widget, then you shouldn't be allowed to do anything to monetize it. Well, you're really tinkering with the public markets. I mean, it would be no different. My analogy is, suppose the company that owned the Empire State Building, suppose it went bankrupt. Does that mean all the tenants in the Empire State Building would not have to pay rent? Well, of course not. I mean, if you said, well, now you don't have to pay rent anymore, then what would be left for the creditors who financed the company that owned the Empire State Building? Nobody in a million years would think that all of a sudden you could rent for free the Empire State Building. Patents are just intellectual property. Time, money, and effort was put into them. If there is value in that ideas, in that technology, then the market should decide. A free market should decide what is that value. And if you want to start suppressing a public market, I think the ripple effect is significant.
And what do you see some of the future challenges for you as a business as you look at monetizing the IP that you have bought, and even if you would consider growing your portfolio?
There's probably a couple of different main challenges. One of them we've talked about is this kind of anti-troll technology, sentiment, which I think is kind of, personally, I think it's a little silly because almost all major tech companies now in some way, shape, or form are looking for ways to monetize their intellectual property, which is the fact that I don't make a widget is discriminatory. I think we need to work on that issue. And then I think you need to work on responsible licensing, meaning some things I happen to agree with when it comes to reform, threatening mom and pop companies with thousands of letters that go out. I don't feel that to be responsible licensing. I think licensing high quality assets with high quality law firms for fair and reasonable terms is where companies in my space should be focused. And I think if we focus on that and we move in that direction and do it responsibly, I think that will help a lot with the image as well.
Have you seen any shift in the reception in terms of your licensing approaches when you do approach a company and
it's no, I haven't seen any shift. In fact, it's still swinging. The pendulum is still swinging the other way. You can make a very reasonable, well thought out, non-confrontational approach to a company that is fairly on notice that they're using the IP and seek a reasonable solution, and we are still routinely ignored. That's not responsible government on the other side of the equation. Those are not companies. Those are companies that are asking us or forcing my hand to file litigation. What am I supposed to do? I have shareholders that expect me to be good stewards of their investment, good stewards of their money, good stewards of their stock. In those situations, you're forcing my hand. That's some of the. So I don't really see the market. I don't see the traditional licensing moving in a more harmonious manner. It seems to be people are getting further and further pulled apart.